Good morning, everyone. Welcome to the 3PB Family Law Brunch with me, Luke Nelson, and my esteemed colleague, Audrey Archer. Welcome to day one of lockdown 2. We hope to make your day a little bit brighter with our 2 talks today. If you have any questions throughout, there is a question and answer box at the bottom bar of the screen. I think it's the far right, it certainly is on my screen. So do feel free to pop a question in there, and either Audrey or myself will do our best to answer it if we can. If there are any connection issues for us, the panelists, don't worry, we will try and log out and then log back on and press on as required. Now, I believe that's all the introduction I can do, so I will now pass you on to Audrey Archer for her talk, Caution, Committal Proceedings.
Thank you, Luke. Good morning, everybody. I'm hoping to take your mind off the first day of lockdown and President Trump by giving you a whistle-stop tour of committal proceedings. And as you will see, the title of my talk is Caution, Committal Proceedings. And you may feel by the end of my talk that you would be feeling somewhat anxious and cautious about making an application for committal. I hope that by the end of my talk, in fact, you will feel that armed with knowledge of the new practice direction 37, along with some insight into recent case law and case law that provides us with some guidance on this subject, that in fact you will be feeling a little bit more confident about making such applications. I'm going to start with the basics, and that being the trigger to committal proceedings, and what of course has to be in place in order to make an application for committal is a contempt of court. And we all often think of a contempt as family lawyers being the breach of an injunctive order, such as a prohibited steps order, non-molestation order, or undertakings. Criminal lawyers often think of contempt by a defendant behaving unruly in court and then finding themselves in the cells for the rest of the day, or being imprisoned for a short amount of time. But in fact, there are other acts that give rise to contempt that we often forget about. And I'm just going to briefly go through those with you so that if you do find yourself wanting to make an application for committal, you can just double check that the act that is the subject of your application does in fact fall into contempt. Breach of an order, of course, is contempt, and breach of undertakings if and only if a penal notice is attached to the order and the undertakings make it very clear that the wording of the penal notice applies to the maker of the undertakings. Contempt of court in the face of the court is another form of act that gives rise to committal proceedings, the making of false statements and interference with the administration of justice. And I'm just going to spend a couple of moments looking at contempt in the face of the court. And the reason for that is because this is probably the type of contempt that happens the most often, but yet is not dealt with as frequently as contempt in relation to breach of orders or undertakings. But it happens on a fairly frequent basis in the family courts and in the criminal courts. In the family courts, contempt in the face of the court is generally behaviour towards parties or to the judge that frustrates the proceedings. And when doing a little bit of research for this talk, I looked at a couple of authorities that exampled what an act would be that gives rise to contempt in the face of the court that's been dealt with by the And I came across an authority whereby a respondent in proceedings was found to be in contempt in the face of the court, because in fact he was found lying on the floor of the court fast asleep, and he'd been there for about 20 minutes. And then it was noticed that he was asleep, and the judge found him in contempt. Another example was where a party tried to throw a dead rat at the judge. It didn't find its way to the judge's bench, but it found its way to the legal advisor's desk. So those are probably quite severe examples of contempt in the face of the court. And the type of contempt that we witness in the face of the court is more abusive behaviour and disorderly behaviour. I practice in crime as well as family. And in crime, it's fairly common to see bad behaviour displayed by defendants, by witnesses, and it being taken seriously. And judges in the criminal courts, who generally have a daily diet of sending people to prison, don't mind initiating contempt proceedings straight away. And the defendant, for example, will often find himself in the cells for the rest of the day, or there'll be an extension on his current serving sentence, or he'll be sentenced to a short term of imprisonment. And certainly I've seen that happen on more than one occasion. I am yet to see a contempt in the face of the court being dealt with by a family judge. And I suspect that that is because they don't have a daily diet of sending people to prison. They are more cautious about the procedure and feel that it can be dealt with in other ways. Or logistically, there are no cells to take the offending party to, matters such as that. So a judge will often simply get up and get out of court or try and calm matters down. I was involved in a case recently. It was on Zoom, and the judge was giving judgment. The father in that case started to use expletives. He was very, very rude. He threatened to kill the judge, and the judge simply put him on mute. So none of us could hear what he was saying, but we could see his arms flaring out and his mouth moving. And I dread to think what sort of contempt he had continued to commit. But that was an example of a judge dealing with contempt in the face of the court by simply putting him onto mute and doing nothing else about it, which may in fact be the better way of resolving it, because I'm sure that father would have calmed down after the judgment was given and reflected on matters. On the other hand, his behaviour wasn't dealt with. And certainly Lord Denning made it very clear that contempt in the face of the court should be dealt with. He expressed in the case of Morris and Crown Office that there is an importance in keeping order and respect in our courts. And he said in that case that the judge's power to find contempt in the face of the court is a necessary and essential power, and it should be used in order to retain respect for our courts and the judiciary. If judges do, in the family court, initiate contempt proceedings in the face of the court, then there has been help guidance provided in terms of what the judge should do and how they should do it in responding to what's happening. And that is set out in the case of Newman and Modern Bookbinders. And this authority provides judges with a step-by-step process as to what should be done when dealing with somebody for contempt in the face of the court. If you find yourself representing somebody who's come to you being made the subject of a committal order in the face of the court because of what he or she has done in court, and they're wanting to know if they can appeal, then it would be good to look at the case of Newman and lawyers look at the process the judge should have gone through to see whether in fact that process was flawed, whether the judge missed giving him the opportunity to fully express himself, to offer remorse at an earlier stage so as not to result in matters proceeding. And so it's a helpful authority to go to if in fact you are looking at whether somebody has an appeal having been found in contempt in the face of the court. I've got 2 slides on that case. You'll see that there's quite a lot listed there, but the slides will be made available after the talk if you should want them. Another case that was quite interesting in terms of how a judge deals with contempt in the face of the court was the case of Wilkinson and the Lord Chancellor's Department. That was in 2003. And the High Court judge in that case was on the receiving end of horrific abuse from a father when she was delivering judgment in a Children Act case. He threatened her, he tried to attack the solicitor who was representing the mother. He threw a bottle of water towards the bench. He had to be restrained by the usher. It was pretty horrific behaviour when you read the judgment. And the judge in that case remanded him straight away to HMP Manchester. That was on a Thursday afternoon. She ensured that he could take legal advice, and the solicitor allocated to the case was only able to see the father on the Friday afternoon. That meant that he appeared back in court on the Monday. And he was dealt with by the judge who sentenced him to 6 months imprisonment for his behaviour. He appealed to the Court of Appeal, and he said that his human rights had been violated by virtue of the judge remanding him straight into custody, him spending more than a day in custody. Of course, he was there over the weekend. And he also made criticism of the judge dealing with him for the contempt, as opposed to handing it over to another judge who hadn't herself or himself been the victim of his behaviour that day. The Court of Appeal swiftly dismissed his appeal. They made no criticism of how the judge dealt with matters. They said ideally another judge could have dealt with the matter. That may have been the better approach. However, the judge was fully justified in this case in dealing with it. She had experienced the behaviour and was best to mark it by way of a sentence. And so the procedure adopted by the judge that day, which was in line with the procedure set out in Newman, was adhered to, the Court of Appeal found, and there was no breach or violation of the father's human rights. Interestingly, the new Practice Direction 37 deals with applications in the face of the court, but in a very short and sweet way. It looks at what a judge should do if no application is made and she or he needs to deal with a contempt. But it refers to a summons being issued to the defendant and all safeguards then put in place as are specified within the practice direction. Those safeguards really relate to contempt, which is applied for on notice. And so, unfortunately, Practice Direction 37.6 deals with cases where no application is made, so contempt in the face of court primarily. Doesn't offer judges much guidance or help in that regard, and so presumably they'll look back to Newman and Wilkinson for guidance on how they should address matters. Other forms of contempt that I've just referred to are false statements being made by a party. If you are representing somebody who is applying for contempt on that basis, you will need to assess whether the false statement is in a document that contains a statement of truth. That is vital. If, for example, you receive a statement from a litigant in person who sends in their statement, but it doesn't contain the statement of truth, and there's clear falsity that can be proved within that statement. Unfortunately, where the statement of truth is not contained within that document, there won't be any cause or justification then for issuing an application for committal. And with false statements, permission is needed by the court to apply on that basis. Interference with the administration of justice, again, permission may be needed in such circumstances, and that relates to matters such as falsifying documents. This type of contempt, in my view, will become more prevalent as technology advances. For example, there is now an application, I understand, that can be downloaded onto your phone or a device, which can alter the content of a text message. And so you can change what's in an iMessage or a WhatsApp message. And parties may, and certainly have, used that facility to change messages so as to make their position more favourable, or so as to make it appear that they haven't made threats or said what they've said in messages. If the court finds that that is proved, that that's what they've done, and have proposed to rely on that, and it's shown that in fact an application has been used to vary or change the content of messages, that would give rise to an interference with the administration of justice. Again, recording hearings would give rise to that form of contempt, or contempt in the face of the court, depending on what stage it's discovered. Either basis can be used. And with so many hearings taking place remotely now, it's very easy for a party to record what's been said on a Zoom hearing, and the next thing is your client discovers that it's been played on Facebook. And an application for contempt then can be made to the court in those circumstances. I'm just going to now move on to the nuts and bolts of making an application for committal. And what I say to you rests really on the New Practice Direction 37, taking into account also case law. So if you have worked out that there is a contempt of court, you make an application under Part 18 and you use form FP2, not the D11. Form FP2 has a section whereby you tick what you're relying upon in support of your application. So the attached witness statement in these circumstances would be affidavit or evidence in Part C of the application. I would suggest ticking both boxes, and within Part C, in that box on the application, just itemising what it is you rely upon in your application. So, for example, you would itemise affidavit, text messages, Facebook messages, Ring doorbell footage. For example, if you've had somebody turning up at your client's front door when he's not supposed to be there, it's part of a non-molestation order, and voice notes, that sort of thing. Itemise that in Part C just by bullet pointing it. That just gives the reader an idea as to whether you have your house in order for making this application. And it could give the reader of the application a good idea as to the strength of your application, because if they see in there that you've gone about things the right way and you've got some concrete evidence that you are purporting to rely upon, if it's set out there, it sets the tone for your application and shows that you know what you're doing. Who do you make the application to? Well, that is to the court that made the order, or, for example, the undertakings that you are saying the respondent has breached. In relation to interference with the administration of justice, you would make your application to the High Court under Part 19 unless the contempt relates to existing proceedings in the family court. So High Court unless you've got current proceedings that the contempt relates to. Permission is only required if, like I say, the application relates to interference with the administration of justice, unless, of course, the matter relates to current proceedings or relates to a false statement being made, then you will need permission. If you do find yourself having to apply permission, please make sure that your application for permission is attached to your application for committal. So it's put in with the application for committal along with the affidavit and the FP2, because the judge will consider the two together. So don't go putting an application for permission separate to your primary application for committal. You've got to do them together. When looking at what you're going to attach to the FP2, that will be the affidavit, primary document, and when preparing the affidavit, please would you go to Practice Direction 22A just to make sure that the affidavit is prepared correctly and as it should be. Practice Direction 22A provides some very helpful guidance in terms of how the affidavit should be set out, how the oath should be made, and gives some crucial guidance in terms of the drafting of that affidavit. Again, I've got a couple of slides dealing with that. I picked out important parts of PD 22A. You'll have a copy of that no doubt yourselves, but you can have the slides to look at the crucial points that I've identified when preparing that. And again, if an affidavit is not drafted properly, it sends a message to the court that it's sloppy preparation, that there's been flippancy in terms of the approach to the application. These applications are serious applications. They've got to be made properly, so you want to get it right. Then just moving on to what the content of the affidavit or the affirmation must have in it. And PD 37 deals with that. It essentially spoon feeds you what's got to be addressed within the affidavit. And you can find that at 37 paragraph 4. And it provides a list, A to S, so some 19 requirements of what needs to be addressed within the affidavit. So the affidavit is probably not going to be a short document. Of those 19 requirements, I'm going to just concentrate on a few that I think are particularly important, because to go through all of them would just simply take too long. What is important is that the word in 37.4 in terms of what needs to be in the affidavit is must. And so A to S, those documents or references or content must be in the affidavit. So everything from A to S is important and should be in there. But like I say, I'm just going to concentrate on a couple of things. Firstly, the date of the undertaking or the order and its terms, that needs to be set out in the affidavit and clearly set out. And of course, what you can do is exhibit the relevant document to the affidavit. So if you've got an N117 that contains the undertakings, that'll have the date on it. It'll also have the notice on it. And so you will have to make sure that that's attached. I'm just conscious of time. I note the time. I've not been able to go through everything, but what I would suggest is that 37.4 is looked at in detail, and that the guidance there is followed. The most important thing that has to be in place for a successful application is that you've got to make sure that the undertakings or the order had a penal notice attached to them. So the undertakings are usually addressed to a particular person. They have the relevant warning on them. Orders need a penal notice in order for committal to be successful. So you will need to set out the content of the penal notice, where it is on the order that applies to your application. And there has been case law to say that that order should be prominently displayed in order to then justify committal later on. So that's just something to be alive to. There are a number of very helpful cases when looking at committal proceedings, CH and C2 2018, and a number of authorities that provide guidance in terms of service, penal notices, and such matters. There are a couple of helpful updating cases in relation to committal proceedings during the pandemic. Those cases I've got on my slides, which can be sent out to you, but they give you the approach, the current approach of the courts to committal proceedings, and the acceptance that committal proceedings at this time can't be carried out in public. And so proceedings have just proceeded on the basis that they are conducted on Skype remotely. However, cases such as Freejack and Yuzu Hair and Beauty stress at disposal. So if a committal order is made, disposal has to be dealt with in public. And if that's not done, there is viewed prejudice to the contemner. There is a helpful checklist as well in the case of Sanchez that's recently been referred to by the High Court in a very recent case in June. That checklist just relates to what you should be looking at if the defendant rather, doesn't attend for a committal application. The checklist that needs to be considered by the court. And then again, if you are representing somebody on an appeal and the court didn't adhere to that checklist set out, it's worth being able to identify a point and use that plank potentially for an appeal against a committal order. I have extensive notes. I've noted the time and I've not been able to cover everything, unfortunately, this morning. The topic is quite vast, but hopefully my notes will be quite succinct and guide you through the process from start to end. I've also, I was going to address you in relation to a couple of cases dealing with sentencing and giving sentencing examples and recent sentencing examples in relation to how the courts have viewed contempt in relation to Talata orders, financial orders, and breach of family orders in relation to children where penal notice was attached. So those cases provide some helpful guidance as to what you can advise a client he or she may be looking at if they are found to be in contempt. Prison is the last resort, and judges will be very alive to the fact that there's a process that they need to go to and follow before imposing a custodial sentence. And so for an applicant, you might want to manage her expectations in relation to the other side, what he may receive by way of imprisonment or other type of disposal. Often parties will think, well, I'm going to go through the committal proceedings and go through the strain of that and what that entails and the cost of it, because the other side will go to prison for what he's done or she's done. That's not always the case, and the courts tend to deal with matters by way of suspended sentence orders, fines, or deferred sentence orders. High Court also has the power to order a person be detained under the Mental Health Act if in fact there is evidence of mental illness and a judge was minded to send them to prison, but in fact that disposal would deal more justly with what has happened and assist the other party in terms of getting some help for their conduct. So that is a very short delve into committal proceedings. Like I say, I've got my notes, I've got my slides that can be sent out. And also if you've got any questions, please don't hesitate to email me directly and I will respond as soon as I can. Thank you.
Thanks, Audrey, for that. That was particularly enlightening for me, not knowing very much at all about that. So I'm very grateful. I'm now going to see if I can share my screen as we go from the dark world of contempt into a little bit more touchy-feely world of the 5 stages of loss in family proceedings. Here we are. Now I'm just going to look to my colleagues to make sure that they can see and therefore you can see my shared screen. Good, excellent. I'm getting the thumbs up from behind the scenes. So today's talk is the 5 stages of loss in family proceedings. what's the point of it? What are we doing here? Well, of course, losses are inevitable. It's not something that we often talk about, on our profiles. My Chambers profile, for example, doesn't include any of my losses. And I'm sure we don't often speak about the losses that we experience, but of course they happen about 50% of the time. And they are obviously a necessary part of family proceedings. If you're in a case, you either win or lose. There's generally no middle ground, despite the efforts of the court to try and minimise the adversarial nature between parties. Now, family proceedings by nature, of course, are highly emotive. People have often spent a lot of their time either in relationships or a lot of their emotional energy raising children. They raise huge issues of what people are going to do with their lives now that they've split up, who's going to look after the children, and other rather large questions like that. So because of that, the feelings that a loss can elicit in a client are particularly deep and particularly strong. And of course, the ramifications for clients are similarly large. In financial remedy proceedings, you might be thinking about somebody losing the home that they've lived in for 15 years. Children Act proceedings, somebody having their child taken out of the jurisdiction with their other parent, or financial proceedings, again, maintenance for a long period of time for an ex that you don't particularly care for. The ramifications are large, as are the length of time that they go on for. It's not like a contractual dispute when if you lose, you pay a bit of money, or sometimes a lot of money, and then move on with your life. These are often large ramifications for a long time. And because of that, what's required to get through these sorts of proceedings is deft client management. And this talk today is my humble hope at helping with that. And it's been inspired by my own experiences with loss in the family courts. So what are the 5 stages? Well, they were introduced by psychologist Elizabeth Kubler-Ross in her book On Death and Dying. Now, obviously, we don't deal with matters of life and death generally in the family courts, although it can certainly feel that way for our clients. Now, what's interesting to note about the 5 stages of grief, as you can probably see from the photograph on the slide, is that they're not linear. They're not cyclical either. You can jump between stages, you can miss stages out, or you can jump back a stage. The point is that these are sort of 5 identifiers of standard behaviours that we might see in these sorts of proceedings. So the 5 stages are denial, anger, bargaining, depression, and acceptance. And it's important to note the depression stage. We're not talking about clinical depression, obviously, but more, I suppose, acute and fundamental sadness that you've lost something. So then, the consequences professionally. There are, of course, consequences for a loss. Sometimes that's just that your client is unhappy with you. Sometimes, and most simply, professionally speaking, is you might be able to appeal. That's not going to cause you too much great disturbance in your sleep. However, if a loss has been particularly crushing, you might be looking at complaints. You can start to feel your blood pressure rising as we go through this list. After that, regulatory referral. Nobody wants the SRA or BSB to be informed about a particular loss if your client's not happy with your work. And then the one that's really going to keep you up at night, intimation of professional negligence. Now, of course, nobody listening to this talk is going to be worried about that, because you're all no doubt excellent lawyers. But it's nonetheless important to remember some of these consequences. And in my view, a lot of them can largely be avoided simply by effective client management. So that's what we're going to try and look at now. So on to the first stage, denial. Now, a client in denial, you might find saying things such as, "This can't be happening. I can't believe the judge made that decision." Or, "Oh, it looks like my ex has again pulled the wool over somebody's eyes. They always get away with it." Now, denial is a particularly insidious stage because hand in hand with that is isolation. And what that can mean is that a client starts to ignore correspondence. The reason why that is bad for us, if it wasn't already apparent, aside from being irritating, not being able to close up matters, that clients in denial might very well not only ignore your correspondence, but ignore correspondence from the other side and potentially ignore a requirement to execute an order. I'm thinking in particular financial cases where there's a transfer with charge back and the party in denial never affects the transfer or the charge. Of course, that has ramifications further down the line because, as you may or may not be aware, slightly beyond the scope of this talk, but one of the grounds for overturning a consent order is that it remains executory, and it, in the circumstances, would be unfair to hold the parties to it. So it's quite important that denial is addressed well. To give you an example of the extent of the way denial can affect clients, I recently acted for a party who had settled a financial case by consent about 12 years previously, and it was settled on the basis of a transfer and chargeback. Now, this was effected, it was executed, so the charge stood, and of course the usual provisions applied. And the relevant one for this case was the party's eldest reaching 18 and finishing secondary education. So the 18th birthday came and went, and the soon-to-be applicant for the enforcement order started asking what's going to happen to the house. And my client ignored these for 2 years until we finally got before the judge in an enforcement application. And at that time, the argument was, it's been very difficult over these 10 years to get over the effects of the breakdown of the marriage. We just need a couple more weeks for a mortgage capacity report, so please adjourn it. Now, 12 years by this point had passed since the consent order was made, and you can imagine what the judge thought about that, and he told me so in no few words. In short, you've had your time, the house is going up for sale. So these issues do come about, and of course there's so much that we can do as professionals to stop that, but it's important to be able to try and see the signs if we can and give our clients a helping hand so we don't find ourselves re-instructed 10 years down the line to make a hopeless application. And finally, and perhaps the most scary for some of us, is the client in denial ignoring fee chasers. You want to close that account at the end of the case, and the client isn't returning your calls and isn't answering your emails or letters. So be careful about denial. Now, anger. You can tell by the photograph I've been watching too much Disney Plus over lockdown. You might expect a client today to say something like that. Judge was an idiot. Actually, you were an idiot as well. Now, the problem with this particular stage of loss is that anger is often the most motivating emotion. And in fact, rather topical that we can see that playing out to some extent in America at the moment with the rather dramatic election. Now, as a result of the motivating nature of anger in proceedings, it behoves us as professionals to address it very, very carefully. Because of course, if we want to avoid some of those professional consequences, we need to make sure that our client's anger doesn't spill over onto us and our handling of the case. Now, an angry client might be angry at various people: the judge, you, or your barrister, or their opponent, or the opponent's barrister or solicitor. Now, it's an important thing to note about anger generally, and you'll have to take my word on this because I've not cited it, but anger is generally in the psychological literature referred to as a secondary emotion. Now, what that means is that anger occurs out of a primary feeling, usually linked to something like inadequacy, but the primary emotions generally linked to anger are fear, humiliation, or frustration. It's not hard to see how any one of those primary emotions might arise in family proceedings, particularly where your party is lost. So it's important to remember that, because if a client's being angry with you, a lot of the time people, when they're treated with anger, might respond in anger. And it's important to remember that that anger is merely just a cover for underlying more, let's say, empathetic emotions. By that I mean emotions that you can empathize with rather than being attacked. So try to focus on those when you're faced with an angry client, angry about the result, angry at the world, maybe angry with you. And if you're able to address those underlying issues, then you might be able to avoid the consequences outlined above. Just remember that it's not personal when someone's angry. It's often more about them than it is you. So, anger. Moving swiftly on to bargaining. Now, bargaining can be the most troubling stage for a family lawyer. And I think particularly for us barristers, when we've got to deal with pages long orders after the event, bargaining can really rear its ugly head. Now, the first point, of course, most likely you might hear your client say, can we appeal this? We must be able to. The judge was an idiot. But if not, then you move on to the next issue that comes up, the post-match analysis. Now, I don't know how many of you have dealt with that. Of course, I can't see any of you, so I'm just going to assume some of you are nodding and understanding what I'm saying. But to me, and certainly I think to the barristers listening, the post-match analysis can arise in one of these sorts of ways. Well, I thought this was relevant. What, you didn't raise the time when they stole my socks and set them on fire? Or what about this thing that you didn't raise? Now, this is a form of bargaining, and it's the client, I think, trying to get right in their own mind the fact that they've had this loss, and they're analysing all the questions put to their opponent in cross-examination, all the submissions made. And of course, as we often know in family proceedings, because of the emotive nature of it, our clients are quite prone to wanting the entirety of their dirty laundry aired in court. And it's our job as legal professionals to try and narrow those issues. So be prepared to be faced with a post-match analysis from a bargaining client if you lose. Slight exacerbation of this comes down to order drafting itself. Clients of mine, unfortunately, had quite high expectations in a Talata and Children Act claim. It didn't go his way, even though he had a positive indication at FDR. This client was in insurance and had quite an attention to detail. It took me 3 weeks to get a final draft of the order. And even then, after pages and pages of amendments and versions, and despite advice to the contrary, some final minor points had to be put back before the judge via email for the matter to be finally concluded. Now, it might just be me, I might just be a total pushover with this particular client, but I'm sure a story like that resonates with some of you. And that is a client who might have lost or had a case that doesn't go their way is desperate to find anything that can make them feel like they can get a leg up. And after a particularly resounding defeat, that can be a rather strong urge indeed. So, bargaining. On to depression. As I said earlier, We're not looking at clinical depression, of course. We're not qualified to be dealing with that. It's more acute sadness that we're looking at here. And it's actually one of the easiest stages, in my opinion, to deal with as a professional, because people, at least it seems to me, when expressing sadness, are really feeling that sort of primary emotion. And it can be easy to be a shoulder to cry on, so to speak, whilst, of course, maintaining your professional distance. So a depressed client might say something like, what was the point in even trying? They always get their own way. But the problem with this, with the depression phase, is that it can quite quickly move to isolation, which is a similar experience to denial. Now, we know what happens when a client is in denial or is isolating themselves from what's happening. That is, they ignore important things that can come back to bite them further down the line. So it's important with depression to be very on it with these clients. You might see quiet resignation, lack of interaction with you, and that's standard, or indeed you might get actual tears, as young Leo is demonstrating so effectively with the single tear down the cheek in my attached photograph. Now, depending on how comfortable you are dealing with human emotion, and I would expect most people on this seminar would be, given the area of law we're in, it is quite easy to handle these situations, but it's important to do it right, because mishandling a depression situation can also quickly turn to anger. And that's because I think a lot of people, when they're sad or they cry in front of somebody who they perceive as strong, like a barrister or a solicitor, and that isn't dealt with in a sensitive way, that of course can lead to feelings of humiliation, which, as we know previously, can then lead to anger. And anger is your danger zone in terms of these stages and trying to maintain your professional integrity, so to speak. So then finally, the stage we all want our clients to get to, acceptance. Now this, of course, is the goal. The emotions are still there, but the client is able to manage them. There is some hopefulness for the future, and they feel able to live with it. And we hear that expression thrown around quite a lot, don't we? Is this an outcome you can live with? And it might not be ideal, but the client at that point is hopefully able to see, well, this has happened and we've got to move on with our lives. It's important to remember that, of course, we can still come back from the feeling of acceptance. Clients might still be upset. They might go back to anger or any of the other stages. But the hope is that they get to acceptance quickly. And so the question that comes out of that is, what can we as professionals do to help clients get to the acceptance stage faster or easier? One of the main ones, in my view, is managing the client's expectations. Now, the case that I told you about when my client was arguing over every word of a draft order largely came about because his expectations weren't effectively managed. That was in part due to the fact that he had a good indication at FDR. And I think in this case, he got in his head that he could win. But it's very important for every step of the way that us as legal professionals properly manage expectations. And I think that goes beyond saying you can never tell what a judge is going to say. And it goes more into sort of specific detail about the ins and outs of the case to effectively manage those expectations, put them to rest. Find the human connection. Now, there's always a fine balance in this career between being a professional, you're being paid by your clients one way or the other to do a job. But that doesn't mean that we have to be robots. And indeed, I think not finding that human connection and appearing more robotic to clients makes you more likely to face something like a complaint or a regulatory referral, because if the client doesn't see you as a person and just sees you as Lawbot 3000, they're less likely to think twice about blaming you for where it all went wrong. And it's a fine balance between overstepping the mark and being too chummy or friendly, and being too robotic. And it's a balance that we all have to find in accordance with our own personal views of the world and the ways that we behave. But often, unfortunately, there's nothing we can do. We're, of course, only there to do a job at the end of the day. We are here to do a service for our clients, and we will act for them in the best way that we can. Their mental health isn't our responsibility, but nevertheless, it's important to be able to see and acknowledge, at least within ourselves, any of the 5 stages of grief or loss they might be experiencing, because it enables us to more effectively meet their needs professionally and individually. But ultimately, in spite of all the work that we do, some people can't be helped unless they want to help themselves. And sometimes all it takes is time to pass by for somebody to learn to accept the new normal. Indeed, as we can see with lockdown number 2 taking place now, it takes time to accept the new normal. And that's it. 5 stages of loss in family proceedings. Time for questions, if there are any. I hope I haven't bored you all to tears. I'm going to stop sharing my screen. Okay. So I'm just taking some time to look through the questions. I don't know if Audrey, if you've been having a look at these as well whilst I've been talking, if there's any that you can answer live. I appreciate we're quite short on time, so it might be that we deal with these after the event. And I think you're on mute still, Audrey, as well.
Thank you. I have answered some on Q&A. I've been trying to get through them. There was one question about non-molestation orders, and if the police are not going to take any action on breach of a non-molestation order, does the aggrieved have relief through the family court? The answer to that is yes, provided that the non-molestation order contains the relevant notice, which is on the standard order. It's set out on the precedent for orders, and it specifically states that alternatively, if you do not obey this order, you'll be guilty of contempt of court and you may be sent to prison, fined, or have your assets seized. So if in fact you have a client who has brought matters to the attention of the police and no further action has been taken, as commonly happens, or the matter gets to court but no evidence is offered, then your client can seek relief through contempt proceedings. You would have to take into account the timescales though, because a respondent can argue abuse of process as a reason to strike out an application. And so if in fact matters go on for months, police are investigating, it gets to the magistrate's court, the Crown Court, and it's doesn't go any further, and a year has passed, the respondent will undoubtedly argue that he has suffered an abusive process and that he's not now in a position to respond properly to the application due to the lapse in time. So you just need to factor in timescales in relation to that. I did in fact experience a response from a judge not so long ago when I was making an application for committal, and I applied to amend the application to include contempt for breach of a non-molestation order. And the response of the judge was, well, Miss Archer, we don't really deal with that in these courts. We haven't since 2007. That's for the criminal courts to deal with. This client had been through the criminal courts without success. And so we were making the application and taking him to the relevant part of the order. he appreciated that in fact it was an application that could be heard in the family court. So if there is no relief in the Crown Magistrates Court, go to the family court if you're in time, if there's not significant delay. Just looking to see if there's some of the questions that have been asked are in fact covered within my notes. So in relation to procedure and who to go to, matters in relation to striking out. So without sort of delving into the ins and outs of all of that, I can send out my notes, as I've mentioned, that cover a lot of what's been asked.
I've just been having a bit of a look through. Audrey, tell me if you've dealt with this one, but I know there's a question about whether an affidavit can be sworn, witnessed during COVID and the lockdown.
Yes, yeah, I just saw that before we went to question time, and that is a very interesting question. And well done for asking that. I don't know the answer to that. I imagine it must be done remotely, because otherwise it would frustrate the whole process and cause significant delay. And the courts have been making efforts to still deal with committal despite requirements not being able to be complied with, such as public hearings and the like. So I imagine if it can be done remotely with somebody who can do that, then that would be satisfactory because of the exceptional circumstances that we're in. But that is a very good question in the current climate. And allowances, I'm sure, must be made. The overriding objective, of course, has to be applied, and to disallow somebody the opportunity to apply in good time because they can't have an affidavit prepared properly would not be just in all the circumstances.
I know that I have somewhat of a side interest in some probate matters, and I know that there's recently been some regulations brought out amending the Wills Act, which allow for the witnessing of wills, etc., to take place via Zoom or online. Because previously that was you couldn't do that. There was some case law, I think, about whether standing outside of the room that they're in was actually properly witnessing. So I know that has taken place in relation to will, so I would imagine that surely would also apply to affidavits as well.
Yes.
But I'm afraid I can't remember the name of the legislation, but I know it's an amendment to the Wills Act. So I can see that it was an anonymous attendee who asked that question. So anonymous attendee, if you just look that up on Google, I'm sure it will. You'll be pointed to the proper regulation. I know it's not much of an answer to say just Google it, but there we have it. And that brings us, I think, nicely to midday. So I think I'll just pass over to Audrey to play us out.
Well, thank you everybody for attending. Our next webinar is on the 3rd of December, and that is going to be talks from Elaine Strachan and Amy Bedis, and is going to relate to financial matters. So I hope lots of you can join that webinar on the 3rd of December.
Thank you all for coming.